be talking about Florida probates and specifically a personal representative. What is a personal representative? What are the responsibilities of a personal representative? If you're looking to become an appointed personal representative in a case, really what does that entail and what should you be expecting? So first of all, a personal representative is the person in charge of an estate administration. Some states call that the executor. The state of Florida, that person is the personal representative. That person represents a fictional entity known as the estate. And I always have our clients think of an estate like a business in the sense that it's a created legal entity that serves the function of gathering assets, making sure that the appropriate beneficiaries are identified, identifying creditor claims, and then subsequently making distribution of the assets to beneficiaries. So that entails several different things. First and foremost is getting somebody appointed. Now, how will you go about doing that is by filing a series of documents in court. Number one, a petition for administration, an oath of personal representative. The person that's the nominated personal representative in the state of Florida cannot be a felon. That person must be over 18 and of sound mind and body. The determination of who is going to be the personal representative in a case depends on if there's a will or if there's no will. In general, if there's a will, then the will dictate who can serve in this capacity as personal representative. If not, if it's an intestate proceeding and there's no will, then the rules of intestacy, and specifically the rules of this concept called preference of appointment, determine who can be appointed. So a person gets appointed and the court issues letters of administration. And really, what's the personal representative's job in Florida? Well, a couple things. Generally, to gather the assets of the estate, and that includes bank accounts, cars, properties, to making sure the assets are secured. After appointment, the personal representative is obligated within 60 days to provide an inventory to the other beneficiaries of the estate, or to the other beneficiaries of the estate, I should say. That inventory lists properties, cars, bank accounts, anything with a known value. Subsequent to the initial inventory, there's notices that go out to the Florida Department of Revenue and some circumstances in the Agency for Healthcare Administration. But in general, the personal representative's job at first is to gather assets. Subsequent to the gathering of the assets, there's a requirement that the personal representative make provision for debt. How do you do that in a Florida probate? Well, the way that I like to explain it to our clients is there's three categories of creditors. There are known creditors, unknown creditors, and then the U.S. government. So known creditors, anybody that the personal representative is aware of that has any debts. And that could be medical bills, cell phone bills, utility bills. Any known creditor is obligated to get specific notice, a document called Notice of Creditors from the personal representative. The second category is unknown creditors that are satisfied through a publication in a newspaper of local circulation. So known creditors get specific notice, unknown creditors get satisfied through a publication. And finally, there's a tax component to an estate administration. There's really two types of taxes that you need to be worried about. Number one, is your estate large enough where it's going to trigger the transfer of wealth tax? Most are not, as that threshold is well over $5 million. The normal category of taxes that we're talking about are federal income taxes that the decedent generated before death. So for example, if you have somebody that passed away in May, a tax return for their final year of life from December to May of the year that they passed away, only to the extent that they generated any taxable income. If the personal representative does not file a final tax return, it's possible that the IRS hold he or she responsible. So it's important that the tax component of an administration be reviewed by a tax professional. So just as an overview, again, letters of administration are obtained to make someone in charge of the estate, and then their job is to gather the assets, inventory the assets, and then make these specific provisions for debt. We have known creditors that get actual service of creditor, of a notice to creditor document. If they don't serve in the case, if they don't file what's called a statement of claim timely, then their claims are barred. All other creditors are satisfied through a publication. The idea being we want to close the window that the personal representative has to worry about creditors, because that gets us into the final phase of the administration, which is to make distribution to the beneficiaries. So we want to get all of the debt identified. We get all the assets, get all the debt identified, and then we're dealing with the net estate. And whatever that consists of, then the next kind of phase of this is to make transfers and distributions. Before doing that, it's a good idea to get an idea from the beneficiaries to whether they're going to require a final accounting. So in order to close an administration estate in Florida, you're either going to need to do a final accounting to show every penny of assets that change from the date of your inventory to the date that you're looking to close, or get all the beneficiaries to waive that obligation. That's called a waiver of a final accounting. So those are the different things that are in play. And once distribution is made or an accounting has been made and served on all the parties, and then distribution can be made, then the personal representative is discharged, distributes all the assets, and the court relieves he or she from any ongoing duty. So if you are considering becoming a personal representative in an estate in the state of Florida and you'd like to discuss this further, let us know. We probate estates throughout the state of Florida, and we offer free, no obligation consultations.